This actually happened. A home seller actually had to pay a $290,000 settlement for this, and I couldn't believe it. This could happen to any seller. That is the scary part. There are 3 times during a real estate transaction when the true value of your home comes under scrutiny, and 2 of these will get you sued. When a buyer feels misled, lawsuits develop. Each of these moments can either build trust with the buyer or raise red flags, depending on how the property was originally presented. First is during the initial showing, buyers will compare your home to other homes on the market to decide if your asking price feels reasonable. With their realtor's guidance and info available, they'll form an opinion of its value, shaping the terms, the negotiation, and the outcome of the purchase agreement. Second is once under contract, the buyer will likely schedule a home inspection to investigate to see if there are any defects or repairs needed that were missed during the initial showing. And the third is if the buyer uses a loan, their lender will require an independent appraisal to verify the home's value and ensure they're not over lending. How you present the property to a potential buyer will determine how much liability you face. Instead of risking a lawsuit, you should know how to avoid them. What if you were looking for a home? The last few years were tough. There weren't many homes available on the market, and you were competing with multiple buyers. You found a home and it checks all the boxes. Yet, you were on a deadline to register your kids for school, so you made a strong offer. Great news, your realtor tells you. They've accepted your offer. Inspection goes great, everything is going as planned, and you decide to drive by the property because you're excited. You start chatting with a local neighbor. Find out that they have kids at the same age as your kids. You mention your kids' school is starting soon, only to realize it's an entirely different school district than you were led to believe. That has to be a mistake, you think. The listing clearly said this home was in the school district you were looking for. You even indicated to your realtor this was a major factor in your home search. Now, this actually happened many years ago. In fact, here in the state of Illinois, where I'm at, the buyers sued for common law fraud, negligent, misrepresentation, and violations of Consumer Fraud and Deceptive Business Practices Act and Real Estate License Act. It was initially dismissed in the lower courts. It was later appealed in the appellate court in favor of the buyer. Misrepresentation is a pretty common lawsuit in real estate transactions. Other examples include misrepresenting square footage, bedroom and bathroom count, property line disputes, updates and renovations, misrepresentation or deceptive marketing of your home. It can erode trust and lead to legal trouble. And here are some tips to avoid this. Be precise when you list your property details and verify all the facts first. School districts, square footage, lot dimensions, room sizes, all of these should be double checked. Instead of stating something is renovated, move-in ready, or recently updated, provide dates and the scope of the work done. Redoing the floor in a kitchen does not qualify as a fully renovated kitchen. For property square footage, break down the area, the main level, the upper level, and the basement. It could also help to provide a floor plan option in your marketing for purposes of transparency. This should be part of your realtor's marketing plan. Now, don't include unfinished areas like the garage, attic, storage, and basement. Be specific and provide the source for the information if you don't feel comfortable being challenged on your own estimations. Rooms, beds, and bathroom count is a common issue and source of confusion. This could depend on your location and how it is defined. Various states have specific regulations regarding what is actually counted as a true bedroom. Check with your realtor or your attorney in your local city or county to make sure you are representing the rooms accurately. Some considerations are the square footage of the rooms, the height of the ceilings, whether they are tandem rooms, and the number of exits, usually 2, one being a window and the other one being a bedroom, depending on the size and the location of the property. I have even seen some states where it is based on whether the septic can handle the number of people living there. For school districts, check with your school and confirm any recent boundary changes. With lot size, check public records or the survey from when you last purchased. When advertising, use specific language and try not to overstate something or be too vague. If you have professional photography taken, and you should, be sure your photographer or editor is not removing things like power lines, changing the color of paint, or over polishing photos that hide the true condition condition of the home, or purposely editing anything that would have an impact on value. It's fine to color correct, color grade, or even do sky replacement, so long as it doesn't impact the realistic view of the property's condition. If you do happen to do this, be sure to disclose that the images are virtually staged. My local multiple listing service requires this disclosure on any edited photos. With some of these new AI tools, you can stage your home with virtual furniture. You can even change out features like flooring and cabinets. This can be very misleading if not fully disclosed. Another quick tip is document everything, ideally from other sources. Double check your realtor's work or marketing. Ask them to sign off on any property descriptions put out to the public. You can even ask your realtor to put into the contract the buyer is responsible for taking their own measurements of square footage and validating the information, placing the burden on them, just as a cautionary condition. In the last 2 decades as a full-time real estate broker, I've been very lucky in that my clients, nor have I, faced any lawsuits, except once. It was a little one, and it was over earnest money. My client, the seller of the home, for whatever reason, stopped responding to phone calls. They just disappeared, and I never heard from them again. The buyer canceled the contract and did so under the terms of the contract, so they were not in breach of the agreement. They wanted their earnest money back, and they were definitely in the right. The problem is with earnest money, both parties have to sign off on it for it to be released. Otherwise, it can't be released without a court order. Since the seller was nowhere to be found, the buyer filed a claim and took all of us to court, my brokerage, the seller, and myself. The seller never showed up, so the judge ordered the release of the earnest money and awarded the buyer an additional monetary judgment against the seller. You can't just ignore terms of the contract. This would result in a breach of contract. This was a small lawsuit, not very dramatic at all, and it was unnecessary. All the seller had to do was sign off on the earnest money if they didn't want to sell their home. A breach of contract occurs when the party involved in a real estate transaction fails to fulfill their agreed upon obligations as outlined in the agreement. This can arise in various scenarios, often leading to significant legal and financial consequences. Every contract is unique, but certain issues can increase the risk of the seller being sued. Common examples include missing deadlines, refusing to release earnest money when the buyer completed all their obligations, failing to close after all the contingencies are met, and not fulfilling obligations outlined in the purchase agreement or the attorney addendums. This may also include delivering clear title, providing a survey, and completing an agreed upon repairs, or failure to leave the property in the conditions stated in the contract. Buyers can sue a seller for specific performance to compel the home sale in certain situations. They may also seek monetary damages, cancellation of the agreement with the return of the earnest money, or even pursue punitive damages if warranted. You should keep clear, well-documented records of communications, which can help resolve disputes more efficiently if issues arise later. So your phone rings. It's the police. Sirens are blaring in the background and your heart starts to sink. Someone viewing your home slipped, fell, and hit their head. We had to call the ambulance, the officer says. Naturally, you're freaking out a bit. Relief floods in when you hear they'll be okay, until weeks later, a certified letter arrives in the mail. You're being sued for negligence. This actually happened. A home seller in California actually had to pay a $290,000 settlement for this, and I couldn't believe it. This was because it was determined that the seller did not provide a safe environment. This could happen to any seller. That is the scary part. In this case, the seller required the buyers to wear shoe coverings during an open house because they just cleaned their carpets. As a result, the shoe coverings plus the wet floors created an unsafe condition that caused the buyer to fall, injuring themselves badly. Other potential dangers like this can result in this type of liability. Those could range from missing handrails, poorly lit stairways or areas of the home, tripping hazards like uneven concrete, and unsafe structures. And like in this case, the repercussions can be severe. This reminds me of an article that I remember reading, famously covered by TMZ. Involved a lawsuit against the CEO of Starbucks, where a construction worker allegedly fell from a ladder after being instructed to wear foot coverings. These incidents demonstrate how negligent claims can arise unexpectedly, even from seemingly minor issues. if left unaddressed, can result in injuries that may lead to costly lawsuits. While you can't prevent every possible accident, taking proactive steps significantly reduces the risk of being held liable. Walk through your home with a critical eye or hire a professional to identify risks. Many of these could show up on the inspection report anyway, so you might as well fix them before these showings start. Consider fixing, repairing, or replacing torn carpeting, cracked concrete, or loose or missing handrails on steps, and ensure proper lighting in all areas. While protecting the floors is understandable, requiring visitors to wear booties or take their shoes off could increase slipping risks. Instead, make them optional and include a clear warning sign of possible slip hazards if you're insistent on having them. Provide a mat to wipe their feet so they are not walking in with wet shoes. Now, if you're worried, it couldn't hurt to check your homeowner's insurance for coverage in case an accident like this occurs. Your home has so much going for it. It's in one of the top school districts where you raised your kids and built countless memories. The neighborhood is family friendly with a park just down the block and a shopping center so close you can walk to it. And let's not forget about those basement finishes you thoughtfully designed as a cozy mother-in-law suite. Those are all fantastic features that can help sell your home quickly and for a great price, or so you thought. 10 days later, you receive a notification by certified mail from the Department of Housing and Urban Development detailing allegations made against you for potential fair housing violations. How crazy is it that a few descriptive words used in what you thought was innocent can get you sued, considered discriminatory, and result in some pretty significant consequences, with a serious legal headache in the form of a fair housing violation. We live in an age where words carry weight, especially in real estate. Fair housing laws are in place to ensure everyone has an equal shot at finding a home and is treated fairly, free from discrimination. This is one of the most heavily regulated areas in our industry. Fair housing laws protect specific classes of people at the federal and state level. Here are the federally protected classes: race, color, religion, national origin, sex, familial status, and disability. And each state may also have its additional protected categories. Phrases like perfect for families, in the best school districts, or even ideal for retirees might sound innocent, but they can be interpreted as exclusionary. You want to avoid saying this or advertising this to any buyers. While you're trying to highlight the home's best features, language like this could signal a preference or discourage certain groups from considering your property. It doesn't stop at advertising either. The way you evaluate offers can also lead to potential violations. For instance, some buyers include what's called a love letter with their offers. These are personal notes that share details about their life, family, or situation. While these can feel heartfelt, they can also reveal information about protected classes and lead to favoritism, even if that is not your intent. If that information influences your decision making, even unintentionally, you could be opening yourself up to liability. To avoid any legal pitfalls, focus on promoting your home in a way that's neutral. Highlight the property's objective features, like its updated kitchen or beautifully designed basement, without framing them in a way that might appeal or exclude specific groups. And when it comes to offers, stick to the numbers and the terms of the contract. The buyer's financial qualifications, contingencies, and proposed timeline should be your primary focus, not the personal story behind the people making the offer. Play it smart and play it fair, and you'll sleep better at night, and so will I. Deanne Reimer-Rowis, associate counsel at National Association of Realtors, she cites a court case in which an agent was ordered to pay $170,000 after being found to have shown reckless disregard for the truth by not disclosing a listing's prior water damage. Transparency is not just nice to have, it's legally required. The guiding question to keep in mind is, does it perform the function for which it was intended, and is it free of any safety or health hazard? The answer is no for either of those, or if you've dealt with past issues, even if resolved, it's always better to disclose. For example, if your roof had a leak but was professionally repaired, disclose it. Buyers will appreciate that. If you had a basement foundation crack sealed years ago, mention it. If your plumbing backed up once but hasn't caused any trouble since, it's still wise to share the history. While technically a fully repaired issue might not legally require disclosure, if the problem resurfaces, the buyer could come after you. And even if you win a lawsuit, you lose. Time, money, and peace of mind and hours you'll never get back. I've seen cases where sellers were sued by buyers over alleged non-disclosure items. The court dismissed the case and the sellers technically won. After months of stress, legal fees, and lost personal time, that victory felt hollow. Over disclosure is your best bet. Being upfront can help prevent misunderstandings, build trust, and reduce the likelihood of costly legal entanglements. Understanding the difference between fraud and negligence is crucial. Fraud is intentional. If you knew about the problem, say a mold issue in the basement, and you purposely hid it or omitted it from the disclosures, that's fraud. Courts don't look kindly upon intentional deception, and the penalties can be severe. Negligence is unintentional but still problematic. Let's say you didn't realize your home's plumbing had a slow leak behind the walls, but a buyer later finds out during a costly repair. The court may determine that you should have known about the issue, especially if there were signs of water stains or musty smell. By being transparent about your property's conditions, you protect yourself from legal risks and ensure a smoother transaction for everybody involved. It's better to lose a buyer front rather than gain a lawsuit later. Over-disclose, stay honest, and let the chips fall where they may. Trust me, it's worth it. Now, I hope I didn't scare you off the idea of selling your home. I just want you to have the best possible results. Getting served with a lawsuit 6 months later that will cost you 3 times your profit does not feel like a win to me. If you decide to sell in the future, you're going to want to have a great realtor on your side. I work with very professional, seasoned realtors across the country. Reach out to me and I can hook you up with someone that will be a great fit. All my contact info is in the description below. If you like this video, be sure to check out this next one right up here. My name's Raymond Kennedy. I've been a full-time realtor for the last 20 years. Thanks for watching. See you next time.